Give a little update. A lot's happened in the district, and I have a lot of frustration, and it's valid frustration because of the fact that this is consumed. Hold on. And it's valid frustration. There it goes. Anyway, because this has consumed literally a year and a half of my life now. So I am trying to make this steady, by the way. Okay. I posted a board policy that they're going to be introducing tomorrow. They were cute, and they put it under the guise of safe student or student safe zones and things like that. Essentially what it is, it's a combination of two things. The outcry of the piss poor job that the district has done as it pertains to protecting the community that has been just decimated by those not nice humans. Again, I can't say what I want to say because it'll get flagged and removed. Why is my shirt backwards? Oh, because I forgot to flip this. Not that it matters, but flip front facing camera. Do I want to do that? No. I don't know if I'm just going to chill with it backwards. Anyway, so the name of the policy, let me get it for you guys real quick. Because I've already posted it on the page. I just want you guys to see it, or want you to hear how I dissect it, because this is not remotely okay at all. Alright. It says board policy LDAJ law enforcement proposed interrogations and investigations for a safe space to learn. The Cobb County School District is committed to maintaining a safe, orderly, and supportive learning environment for all students. This policy establishes clear expectations for how school personnel, when law enforcement officers or other government agents request access to students, student records, or school facilities. The reason that I wanted to state the student records, there's a whole fight in my emails. We'll get to that. Access to students and school facilities. Consistent with the Fourth Amendment of the United States Constitution, law enforcement officers or other government agents will not be permitted to question a student, remove a student from campus, access non-public areas of school property, or obtain student information without appropriate legal authority. Appropriate legal authority. Now that may say government agent, but I assure you, this doesn't apply just to a government agency. This applies to any third party. So the way that they're trying to water this down is they're trying to make it appear as if this doesn't apply to employees within the district who like to look at our records whenever they want to look at them, lock us out of our kids' records, hack into our kids' records, things of that nature without a warrant. So when they state obtain student information without appropriate legal authority, school board attorneys do not have broad sweeping immunity to have access to our records. Our records as in parents, our records as employees, our records as in the students. Okay, verification of a legal authority. Before permitting law enforcement officers, or other government agents to question a student, remove a student from campus, access non-public areas of school property, or obtain student information, school administrators will verify the legal authority presented, meaning a warrant, except in circumstances involving an immediate threat to the health or safety of students or staff. Such authority must be supported by a valid judicial warrant, court order, or other legally binding document issued by a court of competent jurisdiction. For purposes of this policy, administrative detainers or civil immigration documents issued by federal agencies that are not signed by a judge will not be considered judicial warrants. Administrative detainers or civil yes, that's what it said. School personnel, teachers, school personnel cannot independently interpret warrants, subpoenas, or other legal documents presented by outside agencies. So to the 10 users of Thomson Reuters Clear, where's your fucking warrant? To Greg Ellis at HPM, where's your fucking warrant? I'm not done yet. Oh, by the way, except in circumstances involving an immediate threat, that's their way of codifying HB 268, and this is basically a wraparound cover their ass policy, because I've been on their ass since last July asking why have you not adopted this policy when I see it on your website and you're not informing parents. All right, here we go. District legal review. When law enforcement officers or government agents present a warrant, now hold on, law enforcement officers or government agents present a warrant, subpoena, or other legal document requesting access to student records or non-public area of school facilities. The document will be referred to the district's Office of Legal Affairs for review before access is granted. There is a problem with that. The Office of Legal Affairs does not have the authority to grant that. The Office of Legal, the legal office, I'm actually a little stumped on. I'm reading it about 5 times over now, and it's the District Office of Legal Affairs for reviews before access is granted. No, because the Office of Legal Affairs encompasses individuals who are not versed in constitutional law. They are versed in risk mitigation, workers' comp, sexual assault, sexual harassment, but they're not versed in constitutional law. We do not obtain attorneys that can interpret this appropriately. And by the way, the Office of Legal Affairs themselves must have a warrant to look at said records to approve that information to be given to these agencies or entities. School staff will direct all such requests to school administration and district leadership and will not authorize access beyond publicly accessible areas of campus unless a judicial warrant or court order is presented and verified, or there exists an emergency involving an immediate threat to the health or safety of students or staff. Again, the Georgia School Safety Bill. that they didn't codify over a year ago, which they've been using, and they didn't inform anybody, thus out of compliance with OCGA. All right, student records and privacy. In accordance with, in accordance with FERPA, the district will protect the confidentiality of student information and cannot release student records or information to law enforcement or outside agencies except as permitted by law and in accordance with district procedures. Requests for student information will be reviewed through appropriate administrative and legal channels prior to disclosure. Hey, DeKalb County, Greg Ellis, Artis Johnson. I have a question for you guys. Since Sarita was sending you information through an unencrypted Gmail address, did anybody in the Office of Legal Affairs vet this through their administrative and legal channels prior to disclosure of the student records that you obtained for the SAT process? Do you? Yeah, I didn't think so. Okay. When appropriate and not prohibited by law, the district will make reasonable efforts to notify a student's parents or guardian prior to granting access to the student or releasing student information. Reasonable efforts means basically none. Basically none. Training and implementation. The superintendent or designee is authorized to develop procedures to implement this policy and to provide training to staff on responding to law enforcement requests and protecting student privacy. Compliance with law. Nothing in this policy shall be construed or applied in a manner that violates state or federal law requiring compliance or cooperation with lawful law enforcement activity or lawful request for information. All right, so now let me just do this real quick. I think my daughter is about to do something crazy. I don't know if she's. Hold on, I'm trying to see what my daughter's doing. Hold on. What you doing, girlfriend? Already? It's only 7:30. You getting your night snack right now? Okay, girlfriend. Hold on, you guys. I'm back to this now. I can see. All right, so if you comment, I can reply. All right, so what I just read is, all right, there's a whole fight in my email. This is what I filed the 15-page federal complaint over yesterday. The fact that the chief legal officer, who is no longer working at that capacity, Harold Eddy, Kermit Belcher, who's the CIO, basically every attorney for Hobby Smith in the district, Devon Horton, Norman Sauce, the list goes on. I asked for the warrant that would have allowed these individuals to access my records as well as my son's records. And I'm not talking about an innocent access. I'm not talking about they just went in to look. They hacked into my child's records. I have Harold Eddy's IP address through his iPhone 14 Pro Max. So they hacked into his records, and I said, knock it off. 3 days later, as Ms. Qualls was trying to give me my child's batch of records, I go to open the records. Harold Eddy and CIO Kermit Belcher had locked me out of my child's confidential records that contained vital records, HIPAA, fuck FERPA. Uh, just the fact that HIPAA and vital records are involved, no. Extremely sensitive information due to the fact he's on an IEP and has been since he was 3, so they gained access to at least 4, no, 8 evaluations, medical evaluations. No consent, no warrant. They gained access to my information, my husband's information. They were able to get our social security numbers. They were able to get our entire lives. Yet they did not have a warrant. And when I asked them to provide me the warrant, World War III has broken out in my emails. Now, I filed my federal complaint yesterday solely because this has been going on since 2014. They've been sending data to outside agencies since 2014 without your consent, your knowledge. Everyday Labs definitely violates the data privacy clause that they're trying to adopt. Several pieces of curriculum that are being used, that's being Amira, yeah, that violates their own board policy. So the why I'm mad about this one, and I don't like the other stuff that's going on. I am triaging it, as is Taisha, and we're doing what we can. And I'm sorry if we're not working quick enough, but things are happening in the world, and like the kid at Appalachia was sentenced to life with no probation today. Okay, baby. So the reason I'm a little in my feels about this one, I've got emails going all the way back to March of 25, verbatim telling them, you must show us the terms of service, you must show us the data privacy policy, you do not get broad sweeping immunity or broad sweeping consent to look at our record just because you are a school board attorney or just because you are an individual working in the district. You don't. And when the Supreme Court ruled on the geofence warrant, like I've said, that ruled that our digital footprint, which as they are saying in this policy is student privacy, student records, things like that, that falls under digital footprint. The reason they have to use the word Fourth Amendment is due to the Supreme Court ruling, because it's now been established that if you want to touch any of those records, if you want to look at those records, if you want to hack into them as an attorney with a CIO who doesn't know what the hell he's doing because he's messy, you have to have a warrant. If you want to send vital records, HIPAA, and then sensitive information gathered by Thomson Reuters Clear to HPM for the SAP process, well, you're in violation of your new policy, DeKalb. Student records, student privacy. Have we, as parents, given you consent to send that data to HPM? Did we give Sarita consent? Did she get a warrant to send that data and collect that data? No. Oh, no, she didn't. That's right. Because she implemented it without telling anybody, and she was communicating through an unencrypted Gmail app. Somehow I'm the problem. Yeah. I'm somehow the problem. It's not me that's the problem. It's the fact that we don't have anybody in this state that understands my brain other than individuals who have worked with this kind of data and have worked at the same capacity I've worked at. And I definitely ran this by a law firm. They are located in California, where most of these law firms are located due to the nature of data privacy, because we're still out here wilding out with data centers, but people don't understand the reason the data centers are so big in Georgia is because Kemp literally was selling those things to farmers out here where I live. Yeah, he got the farmers to give their land over for a data center. So we've had the first data centers out here for years now. Maybe not, no. The whole data privacy part. I found a law firm full of me's. They communicate in very unorthodox ways because they understand the ramifications of speaking about these things freely. So I ran everything by them. I let them read the contracts. I let them see how it's being used, all of it. And then they stated the same thing I already knew. They said, haven't we already had a $25 million settlement in California for the very same thing? To which I said, yes, you have. But take what they did in California with Thompson Reuters Clear and put it on steroids, because now you're dealing with children's IEPs and their 504s. You're dealing with several layers of federally protected data. To which they said, oh, holy shit. I emailed Glenton Darien today. I put Nina in the email. Nina, I've unblocked you so you can see this. I put Nina in the email because I knew that, inherently the only person that's going to be able to explain the ramifications of what this district has done to every single parent, child, and teacher, the only person that's going to be able to explain the magnitude and just how bad this is would be Nina. Nina knows because I'm the one that warned her about this back in April of 25 when I warned the district about this. She's very well versed on this. So since Nina's one of the 8 law firms, doing employment claims, loosely I know that Parker and Poe does more than just that. I'm not going to say anything else on that part. I'll just state that I know that it's outside of the scope of employment matters. So, Nina, if you come across this, you might want to do them a favor, because the law firm that I'm in contact with in California, yet they actually report to people that I know that all of this has to be reported to. And they definitely take care of whistleblower complaints and protect people like me who make this public. And they're willing to do it. But for every parent and every teacher out that sees this, understand something right now. Within that policy, they have cemented sending your kids information to federal agencies because per OCGA, HB 268, the school safety bill, which you have to dig for on the website. Did you guys know that this was being used? Were any of you told about the HB 268 enrollment form that I posted? How many parents actually saw that you had to fill out this behavior form before you enrolled your child? See, they're having to put this policy in place because they didn't do that, and they had to adopt it. They should have adopted it over a year ago. And the reason that I put the chronic absenteeism stuff out there for everybody that's like crashing out and wanting to defend Norman, I drilled down to students with disabilities for a reason. Those children aren't chronic absentee kids, because if I'm looking at the heat map and then I drill down to the schools, it happens to be children who are missing from these schools in Tiffany's district and Dijon's district and Awett's district and Deirdre's district. The kids aren't missing. The kids are suspended, and they don't report this information to the Georgia Department of Education. Therefore, the discipline dashboards are skewed because they're not actually uploading the referrals, because they're not making the discipline referrals. There are 5 mothers I know personally who have had to send an open record request to get the discipline referrals that are supposed to be freely available to them within Infinite Campus. And they were all Black. I got my child's records with no problem, but my child doesn't have behavioral anything in there because I made them expunge the bullshit that little girl in 1st grade did to my son. So I made them expunge his records. But the mere fact that these moms have had to send in an ORR to get access to their child's behavioral records, which they knew nothing about. They did not know that their children were even in just like in school suspension. They didn't know. So that's why I posted the chronic absentee information, because you have to look at it from the view of this. You need to look at the view of the white kids from stable environments are perfectly fine. So to all the white parents defending Norman, well, that makes sense. Your kids aren't affected. But to everybody else who's trying to give me the definition of chronic absenteeism, yada yada, I know. The point was not that. The point was, did you see how high the students with disability chronic absentee rate went up under Norman? Did you see that it wasn't that high until Norman was put over the insane asylum known as exceptional education? I was trying to show you the correlation. That photo that said N on it, underneath Norman owns that. The state of Georgia had a press release, Georgia DOE had a press release last week regarding the chronic absentee rates in the state of Georgia dipping down again instead of getting better. Meaning we got worse. So maybe just listen to this and maybe go read some things and go enlighten yourself on things that you don't understand. I don't know what you want from me. The only thing I want is somebody in DeKalb County to contact me and let me know when you are going to file a claim of harm for myself and my family due to lack of a warrant and accessing confidential information that you must obtain a warrant for. Furthermore, I've got a federal lawsuit regarding my confidentiality. So where's the warrant, DeKalb County? File a claim with your insurance broker for harm. It's that simple. Gluten Darian, if you do not file a claim, I have held back, but I will go forward and I will file a claim of insurance fraud against you personally. Because I have the emails between you and Harold where you decided to listen to Harold Eddy where he lied to you and said that there was already a pending lawsuit about said claim. And I told you in that email, if you listen to him, you'll be committing insurance fraud. You chose wrong. There's that. To employees in the district when school starts, if things are a little like icky, just kind of hang in there. I've got a feeling that there's going to be some people inside the schools. Definitely going to be a lot of interviews taking place at specific schools. I may have sent the feds every single lawsuit dating back to 2023 and up that involved assault. I definitely highlighted board reps that were named at their capacity. I definitely named Priscilla Weaver or highlighted her name. I definitely highlighted Champion. I definitely highlighted Norman and several other individuals. It might get a little weird, but just do yourself a favor. As long as you haven't done anything wrong, just cooperate. You're fine. But this is what happens when you poke me and you get me to the point of where I'm at. I mean, shit, I'm wearing my Hell Hath No Fury shirt right now. So that's about all I have. But make sure you go read that policy that I just read to you and explained to you, because it's more nuanced than the district wants you to know. And so hopefully what I said helps you understand why that policy is being adopted and drafted, and all the ways it does not absolve them of the felonies that they have already committed. They do not have immunity from what they have already done. I assure you of that. So, have a good night.